The government is using your tax dollars to take your kids, and by the time this video is over, you'll be able to prove it. Not with opinions, not with feelings, with federal statute, with the names of the organizations, with the exact words written into law, with the funding numbers, with the training pipeline, with the lobby behind it. This is not conspiracy theory. Everything that I'm about to show you is publicly available, federally documented, and operating in your state courthouse right now, in your family court. My name is Tammy, and on social media, people know me as the Manicured Mom. I have been vocally advocating for equal shared parenting since 2019. And for the next hour, I'm going to walk you through the most important thing you'll learn about the American family court system and how quickly groups can organize through the federal government and advocacy to quickly strip you of your paternal rights without you even knowing what happened. So please stay with me. This is deep, this is important, and this affects your children. Before we go anywhere, I need to establish a definition because the definition is the entire argument. So stick with me. Coercive control is a pattern of behavior used to take away someone's liberty, autonomy, and freedom. It operates through financial manipulation, controlling access to resources, through isolation, cutting someone off from their entire support system, through imposed rules, creating conditions of compliance, through punishment for non-compliance, and through the use of institutional systems to enforce control. Coercive control does not require physical violence. It is a psychological and structural pattern. It is about power, and it is about maintaining that power through whatever mechanism available. Now, family courts across the country use this exact definition every single day. Judges are trained to recognize coercive control in intimate partner relationships. Attorneys argue it in hearings. Custody evaluators look for it in their assessments. It is one of the most cited concepts in modern family court proceedings. So here's the question that I want you to sit with for the entire length of this video. What do you call it when a more powerful entity identifies what a less powerful entity needs, dangles it, attaches conditions of compliance to getting it, and punishes the less powerful entity financially and institutionally when it refuses to comply? What do you call that pattern? You call that coercive control. And I'm about to show you step by documented step that this is exactly what the federal government of the United States is doing to your family court system, using your tax dollars. To understand what is happening in family court today, you have to understand VAWA, the Violence Against Women Act. VAWA was signed into law in 1994. At the time, it presented as landmark legislation to address domestic violence, sexual assault, and stalking. It created federal funding streams. It established the Office of Violence Against Women within the Department of Justice. And it gave the federal government a formal institutional foothold inside the domestic violence response system. And I want to be clear about something before I go any further. Domestic violence is real. Sexual assault is real, and it happens to both women and men. These are genuine crimes that cause genuine harm. The original intent of VAWA to create resources for genuine victims is not what I'm here to argue about, even though it only addressed women. But what about the men? What I'm here to show you is what VAWA became and what it is being used for today. VAWA has been reauthorized 4 times, in 2000, in 2005, in 2013, and most recently in 2022. Each reauthorization expanded its scope, increased its funding, and attached new conditions to the money it distributes. Within each reauthorization, the reach of the Office of Violence Against Women, the OVW, extended further into the family court system. By 2022, it had reached all the way to your custody hearings. On March 16, 2022, President Joe Biden signed the VAWA Reauthorization Act of 2022. Inside it, beginning at Section 1501, is Title XV, or Title 15, officially named the Keeping Children Safe from Family Violence Act, and it is also known as Kayden's Law. And Title 15 changed everything. I want to spend real time in Title XV or Title 15 because the language is the evidence, and most people, including most attorneys, have never read it carefully. Title 15 is 4 sections long, Section 1501 through Section 1504. Let me walk you through what each one actually does, and this is where you pay attention. Section 1501 establishes the short title, Keeping Children Safe from Family Violence Act, and the findings. The findings section is where Congress states its justification for the law. It references statistics about children exposed to domestic violence, children killed during custody visits, and the role of the family court in those outcomes. The findings establish the emotional architecture of the entire statute. Children in danger, courts failing them, federal intervention required. Here's all the findings Congress cited to justify Title XV of VAWA. And in one of the findings, it states, quote, courts believed less than 1/4 of the claims that a father committed child physical or sexual abuse, end quote. 3 problems with that. 1. The empirical research they are citing traces directly back to a study authored by Joan Meyer, the same woman who wrote this law, funded by the same Department of Justice that enforces it. That is not independent research. That is circular. 2. Courts require evidence. Claims that were not believed may not have been believed because they were not true. The findings never asked that question. 3. This is the one that ends the argument. The statute is supposedly gender neutral, but every statistic in the findings names fathers as the abuser, every single one. So let me show you what the federal government's own 2023 child maltreatment report actually says. Mothers, either alone or with a non-parent, appear as perpetrators in 47.9% of the reported cases of child abuse. Fathers, 28.9%. That is 86,624 more documented cases of abuse by mothers than fathers, at 1.6 times the rate. That is the government's data. The findings also state, and I quote, with respect to cases in which an allegedly abusive parent claimed the mother alienated the child, courts believed only 1 out of 51 claims of sexual molestation by a father, end quote. Read that again. Every pronoun in that sentence is gendered. The abusive parent is assumed to be the father. The alienated parent is the mother. 1 out of 51. The findings cite nearly 800 child murderers by a divorcing or separating parent since 2008. That is across roughly 14 years. Now look at this. This is table 4-4 from the 2023 Child Maltreatment Report. 1 single year of federal data. In 2023 alone, 1,269 children were killed by a parent in 1 year. But here is what the findings don't tell you. Of those child fatalities, fathers alone or with a non-parent account for 19.4%. Mothers alone or with a non-parent account for 48.6%. That is 617 child deaths involving a mother versus 246 involving a father. Mothers are responsible for child fatalities at 2.5 times the rate of fathers in the government's own data. So the findings of federal law cites 800 murderers over 14 years to justify legislation targeting fathers, while their own annual child maltreatment report shows mothers are responsible for child deaths more than twice the rate. They had this data. They chose what to cite, and they chose to name only fathers. Notice what is not in the findings. There is no data on false allegations in custody proceedings. There is no data on parental alienation outcome. There is no data on children harmed by the restriction of a relationship with a loving parent, and that data exists. The findings are constructed entirely from one directional evidence. The law begins from a conclusion. Section 1503 is the operational core of the statute. This is where the mandate lives. It applies to any custody proceeding, and here is the exact language, in which a parent has been alleged to have committed domestic violence or child abuse, including child sexual abuse. Alleged. Not charged with a crime, not convicted, not found liable in a civil proceeding, not even formally accused in a legal filing. Alleged. The word alleged has no evidentiary threshold in this statute at all. It is not defined. It is not qualified. The moment an allegation exists in any form at all, this entire section of federal law activates in your custody case, affecting your custody and your children. I want you to understand how significant that is. You don't need a police report. You don't need CPS findings. You don't need any formal process. Someone says the word abuse, and the federal statutory framework that governs how evidence is handled, how experts can testify, and how judges must respond, all of it kicks in. Section 1503 then says, and I am quoting directly, evidence of past sexual or physical abuse committed by the accused parent shall be considered. Shall be considered. Shall, not may, not should, shall. The word is a legal mandate. It removes judicial discretion entirely. A judge does not get to decide whether this evidence is relevant or reliable, whether it is credible. The statute says shall. The judge must consider it. And the subject of that sentence is the accused parent. Accused. Not convicted, accused. Section 1503 also addresses expert testimony. It says expert evidence in cases involving alleged abuse may only be admitted if the professional possesses, and I quote, demonstrated expertise and clinical experience in working with victims of domestic violence or child abuse, including child sexual abuse, that is not solely of a forensic nature. Unpack that language very carefully. The expert must have clinical experience working with victims. Not perpetrators, not both sides, victims. The statute is requiring that the only expert permitted to testify in your custody case be professionals whose entire clinical framework is built around working with the people who have been harmed. A forensic psychologist, a neutral evaluator trained to assess both parties without a predetermined framework is explicitly excluded if their experience is solely a forensic nature. The neutral evaluator is being pushed out of your family court. The victim center advocate is being brought right into the middle of it. And then there is the reunification therapy provision. Title 15 restricts courts from ordering any reunification program that lacks, quote, peer-reviewed evidence of safety and effectiveness, especially those requiring separation from a safe parent without mutual agreement. So they've decided the alleged is not the safe parent. Reunification therapy is the primary tool family courts use when a child is resisting contact with a parent, often because they are being coached, manipulated, or alienated by the other parent. It is the clinical intervention designed to restore a relationship between a child and a rejected parent. Under Title 15, that tool requires peer-reviewed evidence of effectiveness. Here's the problem. The peer-reviewed literature on reunification therapy is contested, limited, and actively being challenged by the same advocacy organization that lobbied for this law. The practical effect of this provision is that reunification therapy, in the absence of a peer-reviewed standard that can survive legal challenge, is effectively eliminated as a court remedy. So even therapy is not approved at this point. The parent who is the genuine victim of parental alienation just lost their primary avenue of relief. Written out of the statute by a law with the word children in the title. Section 1504 defines the scope. It applies to private family court proceedings, divorce, separation, visitation, paternity, child support, civil protection orders, and custody proceedings affecting the care of children. And here is what it explicitly does not apply to: child protective abuse or neglect proceedings, juvenile justice proceedings. Read that again. The law that claims to protect children from family violence does not apply to proceedings specifically designed to address child abuse. It applies to private custody disputes between parents. This law is not about protecting children from abusers in criminal court. It is about reshaping the outcome of private custody disputes between parents. This is exactly what Section 1504 tells you before you even read it. Now let me show you the financial mechanism, how the money flows, because the law is only as powerful as the enforcement behind it, and the enforcement mechanism for Title 15 is money. The OVW, the Office of Violence Against Women, administers multiple grants. The primary one relevant here is STOP. Services, Training, Officers, Prosecutors. STOP grants flow from the Department of Justice to every state in the country. They fund domestic violence programs, law enforcement training, prosecution resources, and victim services. Every state takes STOP funding. Every state depends on it to sustain programs that the community relies on. Title 15 as a condition to that funding. States that want to maintain their STOP grant eligibility must demonstrate compliance with the mandates in Title 15. They must have laws that limit admissibility of parental alienation evidence. They must mandate judicial training using approved providers. We'll get back to that later. They must adopt the evidence standards embedded within Section 1503. You know, an allegation is apparently what it takes. States that do not comply risk losing their STOP funding. Now I want you to apply the definition that we established at the beginning. The federal government has identified that the state needs STOP grant funding. It has dangled that need. It has attached conditions of compliance. Rewrite your custody laws, train your judges our way, adopt our evidence standards, and it has created a financial punishment for states that refuse. That is coercive control, exercised by the federal government against every single state in the country through the family court system. Your state legislators did not wake up one morning and decide that judges need to be trained using the Duluth model. They did not independently conclude that parental alienation evidence should be restricted. They did not voluntarily decide that reunification therapy should require peer-reviewed backing that does not exist. They did it because Washington and the Office of Violence Against Women held their money hostage. And here is the part that should make your blood boil. The money Washington is holding hostage, it came from you. Every dollar of STOP grant funding distributed to your state is a taxpayer dollar. Your income, your contribution to the federal system, they used your money to build the cage your custody case is now sitting inside of. Remember I said your judges were being trained? To understand what is being taught to your judges, you have to understand the Duluth model. The Domestic Abuse Intervention Project was established in Duluth, Minnesota in 1981. It was created by a feminist named Ellen Pence and Michael Paymore as a coordinated community response to domestic violence. At the center of this model is the power and control wheel, a visual diagram that maps what the model identifies as tactics of domestic violence perpetrators. The wheel places power and control at the center, and around it are 8 spokes, using intimidation, using emotional abuse, using manipulation, minimizing and denying and blaming, using children, using male privilege, no mention of female privilege, using economic abuse, and using coercion and threats. The outer rim of the wheel is labeled physical and sexual violence. The Duluth model's fundamental premise is explicitly stated in its own material. Domestic violence is a gendered issue. It is rooted in patriarchal structure. Men use power and control over women as a function of socialized male dominance. Violence in intimate relationships is not mutual. It is directional. Men are the perpetrators, women are the victims. Did you hear that? This is not a conclusion the Duluth model reaches after examining individual cases. It is a structural assumption the entire model is built on before any case is ever examined. Ellen Pence herself, one of the model's co-creators, acknowledged in later work that the model had limitations. In a 1999 essay, she wrote, and I quote, "By determining that the need or desire for power was the motivating force behind battering, we created a conceptual framework that, in reality, did not fit the lived experiences of many men and women we were working with." The co-creator, Ellen herself, of the Duluth model acknowledged that it did not fit the lived experience of the people it was designed to address. But despite that, the Duluth model became the dominant framework in domestic violence intervention across the United States. It was adopted by courts, by prosecutors, by batterer intervention programs. It became the default. And then, through the VAWA funding pipeline, it was carried directly into your family courts. The Duluth model was never designed for family court custody evaluation. It was never peer-reviewed as a tool for accessing parental fitness. It was never validated for use in determining whether a father should see his children on alternating weekends. But here we are. It was designed for criminal court, for people who had already been convicted of domestic violence crimes, for intervention with adjudicated batterers. But the Office of Violence Against Women designated the Duluth model as the Office of Violence Against Women Approved Training Provider. And VAWA Title 15 mandated that states use OVW approved providers to train their family court judges. So the power and control wheel built 44 years ago to process convicted criminals in Duluth, Minnesota is now the ideological lens which your judge has been trained to look at your custody case. And we wonder why men are losing their children? When you sit in that courtroom, you're not simply being evaluated as a parent. As a man, you're being assessed through a framework that has already decided structurally, ideologically, by design, that men are the danger. That protection means protecting women from men. That the pattern of behavior being watched for is male power and control. If you are a father fighting for equal time with your children, you walked into a room where the training on the wall said you were the problem before you even opened your mouth. Now let me show you exactly who is walking into the training rooms where your judges are being taught. There are 3 primary organizations at the top of this pipeline, and I want to give you their full names, their funding sources, and their documented training content, because this is not speculative. This is publicly available. The NCJFCJ, the National Council of Juvenile and Family Court Judges. The National Council of Juvenile and Family Court Judges is the primary OVW-funded judicial training organization in the United States. They are based in Reno, Nevada. They have been operating since 1937, and for decades, they have been the go-to partner for the federal government when it comes to training family court and juvenile court judges. Within the NCJFCJ is the Family Violence and Domestic Relations Division. The FVDR's stated mission is to support judges and court professionals in handling domestic violence cases. Their training program is called the JEDI-DV, the Judicial Education Development Initiative on Domestic Violence. Their own published training content teaches judges to recognize what they call coercive controlling abuse in intimate partner violence. That phrase, coercive controlling abuse, is Duluth Model language. It is drawn directly from the Power and Control Wheel framework. The NCJFCJ also manages the TA2TA portal, the Technical Assistance to Technical Assistance portal, which is the master directory of every OVW approved training provider in the country. The NCJFCJ controls the list of who gets to train your judges. They are funded by the Office of Violence Against Women, and they are themselves a primary trainer. They control the gate. They approve the providers, they run the training. And the office that writes the check for this all, the Office of Violence Against Women, they fund it all. In 2023 alone, the NCJFCJ received a DOJ UVW grant documented publicly specifically to develop training on custody protective orders and expand judicial education resources. That's your federal tax dollars to that organization to train your judges. The BWJP, the Battered Women's Justice Project. The BWJP does something that most people in the family court reform space are not focused on, and it may be the most consequential piece of this entire pipeline. The BWJP trains custody evaluators. Custody evaluators are the professionals appointed by family court to assess both parents and make recommendations to the judge. They interview the parents, they interview the children, they review the records, they observe interactions, and then they write a report, a custody evaluation that the judge reads and heavily relies on when making a final custody determination. A battered women organization is doing this training. In most cases, the judge has never met you before your hearing. What the judge knows about you, about your parenting, about your relationship with your children comes substantially from that custody evaluation report. The Battered Women's Justice Project, hear that again, trains the people who write the report. Think about what that means before you say one word in a courtroom, before a judge has looked at your face, before you have had any opportunity to present yourself as a parent. The judge has already read an evaluation written by someone trained by an organization whose name tells you exactly what conclusion they begin with. That women are battered and men are the abusers. The Battered Women Justice Project partners directly with the NCJFCJ in their training programs. They are OVW funded, and their training content, like NCJFCJ's, is built on the Domestic Violence Victim-Centered Framework derived from the Duluth Model. And last but not least, the Duluth Model, DAIP itself, the Domestic Abuse Intervention Programs Organization, the organization that created and maintains the Duluth Model, is itself an OVW approved training provider. This is confirmed on their own website. Anyone who wishes to attend their training may do so, and their trainings carry federal OVW approval. So the ideology does not just influence the training pipeline from the outside. The source organization, the one who created the Power and Control Wheel, is sitting inside the approved provider list training practitioners directly. This is not a pipeline where the Duluth Model ideas tickled in informally. The Duluth Model is formally approved, formally listed, and formally operating inside the federal judicial training. Put all three together, and here is what you have. The NCJFCJ trains your judges using Duluth Model derived content and manages the list of everyone else who is approved to do the same. The BWJP, Battered Women, trains the custody evaluators who writes the report your judge reads before your hearing. The Duluth Model itself sits on the approved list and trains practitioners directly. The OVW funds it all, mandates it all, and uses stop, grant, financial coercion to ensure that your state complies. This is not a gap in the system. This is the system. This is the way VAWA built it. Our family courts aren't broken. VAWA wants them to operate this way. The federal framework establishes the structure, but the day-to-day impact on your custody case happens through state-level legislation. And this is where the 3 laws you need to know about come in. Kayden's law, Ohm's law, Kyra's law. Each one is named after a child who was killed. Each one is presented as a child safety measure. Each one, in practice, operationalizes the federal Title XV framework at the state level in ways that directly affect your custody hearing. Let me give you the origins of each one. Kayden Mancuso was a 7-year-old girl in Bucks County, Pennsylvania, who was murdered by her father during a court-ordered unsupervised custody visit in August 2018. Her death was an absolute tragedy. Her father was a murderer, and no reasonable person disputes that the court system that granted him unsupervised access absolutely failed that child. Kayden's law at the federal level, as we have already established, is Title XV of VAWA 2022. At the state level, Pennsylvania signed its own version of Kayden's law in August 2024. Other states are implementing their own versions with varying language. The core provision: courts must consider history of abuse and domestic violence as the highest priority in custody determination. Expert witnesses in abuse-related custody cases must have victim-centered clinical experience. Supervised visitation is the default when abuse is alleged. Listen to that again. Supervised visitation is the default when abuse is alleged, and reunification therapy is restricted. Ohm's Moses Gandhi was a 16-year-old Utah boy murdered by his father during a court-ordered visitation on Mother's Day, 2023. Ohm's law is the Utah state-level equivalent, modeled directly on Kayden's law, but with additional focus on expert witness standards and the regulation of reunification therapy providers specifically. Ohm's law targets the for-profit reunification therapy industry, and on that narrow point, there are 3 legitimate concerns about some bad actors in this space. But the law's practical effect is to further restrict the court's ability to order therapeutic intervention that restores a rejected parent's relationship with their child. Kyra's law originated in New York and is being pushed in other states. It is the most aggressive of the 3. Kyra's law does 3 things. It makes child safety the stated top priority in all custody proceedings, which I don't have a problem with, but it's framed in a way that centers abuse allegations over other factors. It mandates judicial training on domestic violence and child abuse, and this is the critical one. It requires courts to conduct a prompt evidentiary hearing and consider temporary protective action when any party asserts what the law calls facially credible allegations that would pose a substantial risk to a child's safety. Facially credible allegations. That standard means the allegation appears to be credible on its face. It does not mean it has been investigated. It does not mean there is cooperating evidence. It does not mean a professional has assessed its validity or credibility. It means it sounds believable when somebody says it. Under Kyra's law, a parent can make an allegation that sounds credible and trigger a court hearing that results in the temporary suspension of the other parent's parenting time before any proof, before any findings, on the face of the allegation alone. Now, combined with what Title XV establishes, that the word alleged is sufficient to activate the entire federal statutory framework around expert testimony and evidence standards, an allegation that sounds credible can suspend your parenting time under Kyra's law. The same allegation activates Title XV evidentiary framework requiring victim-centered experts, mandating the consideration of abuse evidence, restricting reunification therapy. And all that happens before you have been charged with anything, before you have had a single hearing, before a single fact has been established. This is the allegation as evidence, not in theory, in statute. Now, here's the question you should be asking. Do any of these 3 laws address parental alienation? The answer is no. And yes, none of these 3 laws use the phrase parental alienation, but Title XV statutory language explicitly limits, and I quote, the admissibility of evidence and testimony regarding parental alienation as a condition of stop grant compliance. The restriction flows into the state law through the compliance mandate, and the practical effect of restricting reunification therapy, as all 3 laws do in varying degrees, is that a parent whose child is being alienated loses the primary court-ordered remedy available to them. You cannot raise effective alienation claims in a court that has been trained to deprioritize them. You cannot assess reunification therapy in a court that has been told to restrict it. You cannot overcome a facially credible abuse allegation in a proceeding where the word alleged is sufficient to activate a federal statutory framework. that treats you as an accused perpetrator. The parent who is a genuine victim of parental alienation is structurally locked out of every single avenue of release by laws with children's names on them, by laws to make you have sympathy about those children. And how dare you question it because of those children. Now I want you to understand that none of this happened by accident. There is a documented lobby behind every piece of legislation that I have described. And I want to introduce you to the key players by name with their own words. Now, the National Organization for Women. Shocking, right? Now lobbied for the original Violence Against Women Act for 4 years beginning in 1990. They have been involved in every single VAWA reauthorization since. Their own published newsletters and policy materials explicitly oppose parental alienation as a valid legal concept in custody proceedings. It's referred to as pseudoscience. They have advocated for the restriction of reunification therapy, and they have consistently supported the expansion of the Duluth Model framework into family courts. Their alignment with the Duluth Model's gendered framework is not incidental, it is ideological. The same premise that domestic violence is a function of male power and control is the premise that animates every family court policy position they take. The NNEDV, National Network to End Domestic Violence. The NNEDV is a core VAWA advocacy organization and is a direct OVW funded partner. They lobby in every state legislative session for implementation of the federal Title XV framework. They provide model legislation, they train state level advocates, and they are part of the network that connects the federal funding to the state level policy changes. Future Without Violence. Their own website calls them a driving force behind the 1994 VAWA. They are Office of Violence Against Women, OVW funded. They train legal practitioners and advocates at the state level to apply the domestic violence centered framework in custody cases. They are a significant part of how the ideology moves from federal policy to state courtroom practice. The Safe and Together Institute. The Safe and Together Institute trains lawyers, judges, social workers, and custody evaluators. Their model teaches practitioners to center the domestic violence survivor's experience in all child welfare and custody decisions. It explicitly de-emphasizes parental alienation claims. It frames a parent's resistance to the other parent's access as a potential indicator of abuse rather than a potential alienation behavior. Their training is being adopted by courts and child welfare agencies across this country, and their framework is entirely consistent with and derived from the Duluth Model's Gender, Power, and Control Wheel Foundation. Every one of these organizations uses the same Duluth Model ideological framework. Several are directly Office of Violence Against Women funded. They all lobby for the same family of laws: VAWA reauthorization, Kayden's law, Ohm's law, Kyra's law. They all oppose parental alienation as a legal concept, and they all support the restriction of reunification therapy. This is not a collection of independent organizations who happen to agree. This is a coordinated policy ecosystem, funded, organized, and operating a unified legislative agenda. But I need you to take this deeper, because behind this entire legislative framework are three specific people whose names you need to know, because they are not just lobbying for these laws. Two of them actually wrote them. Joan Meyer, professor of clinical law and director of the National Family Violence Law Center at George Washington University Law School in Washington, D.C. Danielle Pollack, policy manager at the same center, and by her own biography, the originator of Kayden's law. These two women did not just lobby for Title XV of VAWA 2022, they wrote it. Joan Meyer and Danielle Pollack personally drafted the statutory language in Title XV, the exact words I read you in Chapter 3. Together with Pennsylvania Congressman Brian Fitzpatrick, they then advanced it alongside Kayden's law, RAIN, and advocates including Angelina Jolie. And then when President Biden signed it into law on March 16, 2022, Joan and Danielle were invited to the White House to watch. Every word you heard me read from that statute, alleged, accused, shall be considered facially credible, peer-reviewed evidence, those are words of Joe Meyer and Danielle Pollack. But they did not stop there. The National Family Violence Law Center manages what they call the National Legislative Clearinghouse. This is a centralized hub that develops model custody legislation, template bills, and distributes them to lawmakers in every state across the country. Their own website says it provides technical assistance to states and federal policymakers seeking to adopt VAWA provisions. Danielle Pollack is currently traveling state to state. Her documented work includes Connecticut's Jennifer's Law, Colorado's Julie's Law, Florida's Grayson's Law, Pennsylvania's Kayden's law, Washington State's coercive control law, Utah's Ohm's law, and Louisiana legislation. She is in the room where every one of these bills is being written. She is the technical assistant. She is the person who your state legislators call when they need help drafting language. Joan Meyer authored the 2020 DOJ-funded study that is the single most cited piece of research used to justify restricting parental alienation claims in custody proceedings. The study that every organization in this ecosystem, NOW, NNEDV, One Mom's Battle, points to as the empirical foundation for everything they are pushing. Let me say that again so the full weight of it lands. The study used to justify the law was funded by the same Department of Justice that administers the STOP grants. It was researched by the same professor who co-wrote the law. It is cited by the organizations lobbying for the law, and it is being used in service of legislation that is changing your custody cases and taking away your children. The research justifies the law. The law funds the training. The training shapes the judges, and the same people are at the center of all three. And there's one more. There is Tina Swiffen, who is the founder of One Mom's Battle, a community of 250,000 people, where Joan and Danielle build the architecture, writing the statutes, drafting the model legislation, briefing the lawmakers. Tina mobilizes the army on social media and across multiple apps. Her Legislative Action Hub directs a 250,000 people audience to contact specific legislators about specific bills at specific moments in the legislative calendar. She testifies before legislators. She has helped pass legislation in multiple states by her own account. She is the political pressure that gets the votes across the finish line. Joan Meyer and Danielle Pollack write the blueprint. Tina Swiffen fills the room. 3 people, 1 coordinated structure, a legislative clearinghouse drafting bills, a DOJ-funded study providing the academic cover, a White House signing ceremony providing the legitimacy, a 250,000 person army providing the political pressure, and a federal funding mechanism ensuring that every state complies. This is not grassroots advocacy. This is a fully engineered legislative pipeline with academic credibility, federal funding, and organizational infrastructure that has been operating for over a decade and has now reached every state in the country. And the output of this pipeline is the family court system. And if you're a father, it's the one that says you are the perpetrator because mom is the victim. I've spent the last hour building the case that VAWA's foundational design, the allegation as the instrument, credibility as the threshold, creates a system that can be weaponized. I do not need you to take my word for it anymore. In 2025, the United States Citizenship and Immigration Services, USCIS, published an official federal alert. The title of that alert is USCIS Restores Integrity to VAWA Domestic Violence Program After Finding Rampant Fraud. Those are not my words. That is a federal government agency using the word rampant fraud about VAWA, officially published on uscis.gov, rampant fraud. Here is what their own data showed. Between fiscal years 2020 and 2024, VAWA self-petitions increased by 360%. Male petitioners, people using VAWA to claim they were abused, increased by 259%. And parent-based VAWA petitions increased by 2,239%. 2,239%. The federal government's own agency documented that their own VAWA program was being systematically abused at a massive scale, that people were manufacturing abuse allegations to assess federal protections they were not entitled to. Now, I need to be precise here because precision is what makes the argument unbeatable. This USCIS alert applies specifically to the immigration side of VAWA, the self-petition program that allows non-citizen survivors to obtain immigration status. It does not directly address Title XV family court provisions. I'm telling you that so that nobody can use it against you. But here is what the distinction actually reveals. The federal government looked at the immigration VAWA program, which runs on the same foundational design as the family court framework. Allegations as the instrument, credibility as the only threshold, no evidentiary floor. They found rampant fraud. They found a 239% increase in parent-based petitions, and their response was to reinstate evidentiary requirements, to require proof of actual residence, to demand primary evidence of the relationship, to raise the threshold above a credible sounding allegation. They proved their own design is exploitable, that it was being weaponized, and they fixed it in the immigration context. Title 15 Family Court Framework runs on the identical design. The word alleged still activates the entire statutory framework with no evidentiary threshold. Kyra's law's facially credible standard still allows parenting time to be suspended on an allegation that sounds believable, and no equivalent evidentiary correction has been applied to family court. The government found the flaw. They named it rampant fraud. They fixed it in immigration and left it completely intact in the place that determines whether or not you get to see your children. USCIS responded by reinstating evidentiary requirements, proof of actual residence with an alleged abuser, primary evidence of the relationship, verification systems to detect fraud. In other words, they looked at a system where an allegation was the only threshold, watched it produce fraud at a scale of 2,239% higher, and concluded that evidentiary thresholds are necessary to prevent exploitation. They know how to fix it. The fix exists. They already applied it somewhere else. They fixed it in immigration. They called it rampant fraud, and they left the identical design running in your family court, untouched, uncorrected, and fully operational. The same organization that lobbied for Title 15 are actively opposing any attempt to apply equivalent evidentiary standards to family court. The same standards USCIS just decided were necessary to prevent rampant fraud. Those organizations are fighting to keep out of the custody system that affects your children. The government's own confession is on record. The data is public. The word rampant is in the official title. The fix exists because they already applied it somewhere else. They know how to fix it. They are choosing not to fix it in your courtroom. Now ask yourself why. I've spent the last few chapters showing you the structure. Now I want to show you what this does to a real person. I want you to picture a parent, a mother or a father, because honestly, it happens to both. This parent is a genuine victim of parental alienation. Their child is being coached by the other parent to fear them, to reject them, to say things about them that are not true. The alienating parent has been doing this systematically, restricting phone calls, monitoring conversations, reframing normal parenting as dangerous, cultivating in the child a narrative that the targeted parent is someone to be afraid of. This parent goes to family court. Under the framework, the one built by Title 15, trained into judges by the NCJFCJ and the Battered Women Organization, and reinforced by Kayden's Law and Ohm's Law and Kyra's Law, here's what happens. The alienating parent's attorney files a motion citing concerns about the child's safety. The allegation is facially credible, and it is framed professionally, and it references the child's stated fear, and it sounds believable. Under Kyra's Law, this triggers a hearing and a potential temporary suspension of the targeted parent's parenting time. Title 15 activates. The targeted parent is now the accused. The shall be considered mandate applies. The victim-centered framework applies. The custody evaluator, trained by the BWJP, the Battered Women Justice Project, assesses the family. The evaluator's training has taught them to look for patterns of coercive control. The child's resistance to the targeted parent is within the Duluth Model framework, potentially read as evidence of the targeted parent's controlling behavior rather than evidence of the alienating parent's coaching. The judge, trained by NCJFCJ using Jedi DV curriculum built on the Duluth Model language, has been educated to center the abuse allegations and to approach the case with a victim-centered framework that says men are the perpetrators and women are the victims. The targeted parent asks for reunification therapy. The Title 15 peer-reviewed standard restriction is raised. The program available does not meet the standards as defined within the framework. Reunification therapy is denied. The targeted parent tries to raise parental alienation as a legal claim. Title 15 has limited the admissibility of parental alienation evidence. Their attorney faces an uphill battle in the courtroom, trained to receive that claim as skepticism. The alienating parent walks out with primary custody, a protection order, and supervised visitation for the targeted parent, pending further evaluation. The child goes home with the parent who coached them to lie. And the system, at every step, worked exactly as VAWA designed it to do, exactly as these organizations wanted, exactly as these three women wanted it to. This is not a hypothetical. Versions of this scenario are playing out in family courts across the country every single day. The framework guarantees it. The training reinforces it. The law enables it. And the lobby celebrates it all the way. The system is not broken. The system is working exactly as VAWA planned. Now, I'm not ending this video without giving you something to do, because something needs to be done. Because awareness without action is just pain. Here is what every parent watching this needs to do right now. First, know your state's compliance status. Go to your state legislator's website. Search for how your state implemented VAWA Title XV compliance. Search for Kayden's law, Ohm's law, Kyra's law, or something similar. Find out which of these has been introduced and passed in your state. Know what language landscape you are walking into. Second, know your judge's training. File a public records request with your local courthouse asking what judicial training programs your assigned judge has completed and which organizations provided that training. This is public information in most states. Get it. Third, know your custody evaluator's training. Before any evaluation begins, ask in writing what training your evaluator has received and from which organization. Ask specifically whether they have received training from the Battered Women Justice Project, the Safe Together Institute, or any Office of Violence Against Women funded program. Put it on the record. Fourth, contact your federal representatives. The stop grant mechanism is federal. The Office of Violence Against Women agency, it's federal. The approved provider list is a federal document. Your senators and your House reps have oversight authority over the DOJ and the Office of Violence Against Women. Contact them. Tell them you have watched this video. Tell them what you know about the Title 15 compliance mandate. Tell them you want hearings on the Office of Violence Against Women approved training list and the ideological framework being used to train family court judges with federal money. And fifth, share this video. Every parent in a custody case in this country needs to understand this pipeline before they walk into a courtroom. Share it with every single parent you know. Share it with attorneys. Share it with legislators. Share it with journalists. This information, the information in this video is all publicly documented. It cannot be dismissed as conspiracy. It is a federal law, federal funding, and named organizations doing documented training. Sixth, organize at your state level. The state level laws are where the most immediate change is possible. Equal shared parenting bills, time taken, time back bills, parental bill of rights bills. These are the legislative counter moves to this. Title 15 framework. Find out what is active in your state. Find your state's shared parenting advocacy organizations. Show up. The people who built this system organized. They lobbied, they wrote legislation, they trained judges, they built the pipeline over 30 years. The answer to a 30-year organized effort is an organized effort. They had a blueprint and they followed it. Now you have a blueprint. You know the players, you know the funding mechanism, you know the training pipeline, you know the laws. Now use it. The system is not broken. The system is working exactly as VAWA planned it to be and exactly as the Office of Violence Against Women funded it. The question is whether or not you're going to let it keep working, whether you're going to become the reason it changes, whether you're going to get loud, because without you, we can't change this. We need everybody organized and working together. Ta-da! If you made it to the end of this video, thank you. I know that this was a lot. It was meant to be, because the people who built this system are counting on it being too complicated for you to understand, being too complicated to talk about, too dense for explanation to your friends, too buried in legal language to make it into a TikTok. I tried in a 7-part series and they suppressed it in the algorithm. Shocking. They built it that way on purpose. They built it to scare people away from talking about it. But you just watched the whole thing. You understand it now, and you can't unknow it. Share this video, save this video, come back to it, use it. Every chapter is timestamped in the description. Every organization named in this video is publicly documented. Every statute cited is real and linked below. Get loud because we need you to. Get loud because this is your tax dollars, their ideology, your custody if we don't do something about it. My name is Tammy. I'm the Manicured Mom, and I'll see you on the next one. Thanks for watching.